Good afternoon, dear guests. Good afternoon to everyone who watch us online. The topic of the next press briefing is public service and administrative justice, achievements and challenges. Our guests are Mykhailo Smokovych, judge of the Cassation Administrative Court. Head of the Cassation Administrative Court at the Supreme Court of Ukraine, Lars, President of the Higher Administrative Court of the Federal State of Rhineland-Palatinate, Germany, and also Veronika, Krumina, Judge, the Chair of the Department of the Administrative Cases, Supreme Court of Latvia. Welcome. Dear guests, we have 10 minutes each. Good afternoon, dear citizens of Ukraine. Good afternoon, those who are present here today. Today we have the 6th of July 2018, and on this date, 13 years ago, the Supreme Council of Ukraine at 5 p.m. adopted the Code of Administrative Justice of Ukraine, and this is an important document for Ukraine, the main achievement and the mechanism due to which our citizens can control the bodies of power and the bodies of local self-governance. And in explanatory notes and while speaking during the session of Verkhovna Rada, it was stated that the adoption of this code is really necessary for the protection of rights of Ukrainian citizens, rights and freedoms of people, citizens of Ukraine in Ukraine. And at that time, during political crises, this was really important. And it was the year before the elections of the deputies in 2006, and for the first time in the history of Ukraine, these were the elections on proportional basis. And in order to protect this system and to protect voting rights, this administrative justice was introduced then. And life shows and experience shows and our work in administrative court prove that this protects not only voting rights, but electoral rights, but all other interests of physical and legal persons in the sphere of public and legal relations. During this time, courts, local courts, they heard about 11 million cases, administrative cases, and this is huge number of cases, and the citizens of Ukraine were able to get protection of their rights, and also cassation courts, higher administrative court and cassation court also heard more than 700,000 cases. Statistical data, 67 or 70% in these cases, the claims of the citizens were satisfied, so they found protection, and it is pleasant that they were protected, but in this court decisions, the illegality or inappropriate actions of local government was revealed, and it characterizes them negatively. And if they acted in accordance with Constitution and the laws of Ukraine, we won't have such cases in administrative courts. And also about those years that passed and the experience of administrative courts. In 2018, as of today, as of the adoption of the court, so this day, we had the international conference, the first one, and the topic is public service and administrative justice achievements and challenges is the title of this conference. And we will have a tradition to hold such events. And in administrative courts, the judges took decision to hold the days of administrative justice in Ukraine. And as of today, if you're interested on the sites of administrative courts, you may see how they celebrate this day. For example, they hold seminars, or, for example, they can have some exhibitions. For example, how children view the courts. Also, the meetings with the vulnerable categories of population who need protection in administrative courts, and other events, including contests in some sports. So why this topic was selected for the first international conference? Because we have a reform of public service in Ukraine that is ongoing, and we see new laws on public service and national police, and also new edition of the law on prosecutor's office, and also the law on courts and the status of judges and other laws. And they all regulate the activity of our servants, our public servants, who work in the bodies of power and also in self-governance bodies. And these bodies of power, they should have the best servants that will be selected through the contest, because the work of these bodies depend on these employees. And administrative courts, they oversee the procedures of the contest, and how people are hired and fired from the service. And we understand the importance of these processes in Ukraine, and it was decided to take this topic for the conference. And you know that today in Ukraine, these processes of reforms are ongoing, the processes of cleansing of state bodies from servants who are not capable of holding these posts, and also the processes of considering the cases concerning dismissal of officials, servants, and also the dismissal of some law enforcers, dismissal of some police officers, and also there are many disputes in administrative courts concerning these cases, and also there is qualification assessment of judges who, according to Constitution, should confirm their competence and impartiality for being on these positions, and based on the results of these procedures, not all stay satisfied with the decisions, and they appeal in administrative courts. And in order to protect the rights and freedoms of people, in order to provide fair decisions, we invited to our conference the scientists and those who practice the law, and judges of Cassation administrative courts, and the judges of other courts, appeal and district court judges who consider these cases and take care of these cases. So we are really grateful that our partners came to us from Germany, Lars and also from Latvia, Veronika Krumina, and also many judges came, and they are from Poland, and they also take care of these issues, and they share their experience concerning hearing of cases, and also about civil service in their country. And we, Ukrainians, for us, this institution of administrative justice is new, and we try to get experience from other countries in order to build our system of administrative justice, and to have the same principles, the same rules and tasks, and according to the standards according to which administrative courts in other countries work. And we are really grateful that we can share the experience, and we've reached this high level of administrative justice, and we can share the experience with other countries. And I believe that now we went into the details concerning some cases. We share the experience about the cases, and also we get experience from other countries. So this is what I wanted to tell you, dear citizens of Ukraine. Thank you, Mykhailo. Now the floor is given to Lars Broker. I would like to provide two messages. First, concerning this date, and second, about the conference mentioned by the head of the administrative court. The law that was mentioned here, that was adopted, this is the instrument that is given for the use in administrative courts. But from the other side, this instrument, it sounds technical, and without this instrument, the state won't be able to complete one of its main tasks for its citizens. Because the idea of the state, of the democratic state, is that the state is for its citizens, not otherwise. And that's why this obligation of the state before its citizens is that the state creates the instrument through which the citizen can address the administrative court in order to be protected, to get protection from violation of his rights. The administrative courts are the courts that implement this obligation of the state before its citizens to provide protection. That's why it is viewed as a special court, and there's a special attitude to the court, because due to which, through these courts, the citizens can protect themselves from actions or inaction of the state. And from the other side, administrative courts are important for the state, because through court practice, they show that level of provision of rights of citizens in relations with the state and how Ukraine is viewed by European community on its way to European community and European Union. And I, as an advisor to this party, I'm really grateful that I'm the part of this process of helping Ukraine to establish the system and administrative courts. And maybe you remember that in the Soviet Union, you cannot even imagine the citizens, they were not able to complain, to file the case against the state. It was impossible. And Ukraine went back to the tradition that was established in 1919, when the citizens were able to appeal against the actions of the state. And this was the same for the countries then. And these are old traditions. They are for the whole Europe, and we should return these traditions here in this country. And we are really grateful for this cooperation between our administrative judges and also and we are really grateful that we were able to participate in the process of adoption of the code and how this cooperation developed. I would like to briefly say about it. Quickly, we started not to tell about some different things. We went to one level and we started to share the experience and to consider those problems of justice. So we started to speak equally at one level. And this is a characteristic. And we see that administrative justice in Ukraine works both theoretically and practically with participation of scientists, and due to their help, the administrative justice went to high level. And now, we are not speaking about overall theoretical things. We now analyze the practice, the cases, and we see that we have a lot of common, and we ask each other how to resolve the case, and we have a collegial way of resolving things. And last, about the conference that was mentioned here. And what I saw during this conference, that former High Administrative Court, now the Higher Cassation Court, it develops on the development of the administrative justice, including material administrative law, because sometimes a lot of courts, they just consider their practice and they do not look out of their plate. And we are glad that the head of the Cassation Administrative Court, Mr. Smokovych, wants to broaden these horizons. And the judges, they meet not only in administrative court, also on the first and second level of justice. Those judges also meet among themselves to discuss matters. And also they actively, the scientists actively participate, and I saw many young specialists, young scientists. They have new views on administrative laws, and they are ready for further development of this field. And we are really proud that our Ukrainian colleagues, they look not only outside their own plate, but also outside their borders, and we are really grateful for being invited to participate in this event. And this sharing of experience, both we and our colleagues need this, because they grew up from this small childish boots, and they are moving ahead really quickly, and we hope for fruitful cooperation in the future. Thank you very much. And now the floor is given to Veronika Krumina. I'm going to speak Russian. It's easier for me. In Latvia, administrative courts started their work in 2004, and the Code of Administrative Proceedings also was introduced the same year. And we are on the same wave, because Ukrainian colleagues, when they elaborated the law on administrative proceedings and developed administrative proceedings, they looked at their colleagues in Germany, and we also looked at our colleagues in Germany and saw how this administrative process develops in Germany. And here my colleagues mentioned that in principle administrative process is the main process in order to protect individuals or individual human rights. This is the mechanism that should be in place in the country in order that a person could speak at the same level with the governmental institutions and with the, ask for proper decisions, and why can ask why some decisions were made, why something was prohibited, or why some obligations are given. I believe, because I see that Ukrainian colleagues, they have the same way. In Latvia, when we organized the administrative courts, these were new courts, and there was special selection of judges, and the court system, new judges came to the system, and these new judges, they had new thinking. And I would like to note that with the creation of these administrative courts, we started discussion about the quality of decisions and the quality about the quality of decisions and about the quality of hearings. It is important that people who come to court, they should see that the court is interested and wants to resolve the case in a fair manner, in order that people trust in the fairness and impartiality of the court. And if people believe in this judge and the court, then people will believe the state. This is a big task for the judges, and we should understand that the trust to the state, this is an important element that can be strengthened by the judge. And about the conference, I'm really grateful to my colleagues from Ukraine who invited us and gave the opportunity to share the experience about the hearing of the cases concerning public service. And as you may see, these problems that were considered during the conference. And when we speak outside the conference, we may see that we have similar problems. What I wanted to say is that about administrative court and its contribution for the country. And in Ukraine, I believe this is the same positive thing. Before, administrative courts in Latvia, many decisions were not well grounded. For example, something was not provided and no proper grounds for this. And the administrative court could cancel those decisions, and step by step institutions and servants, they got accustomed that they should ground their decision, provide proper ground for their decisions, and also to see that these decisions, they should be, they shouldn't provide too much sanctions for some situations. And we believe that in the future we will have an opportunity to share the experience concerning different administrative cases, and this cooperation will continue. Thank you. Thank you. Mykhailo, do you have something to add? If no, we will continue with the questions. Do you have questions? Kristina Poželušna, Legal Practice News Outlet. I have a question to all the speakers. I would like to start with Veronika. I would like to specify, and why did you have the need for the introduction of administrative justice? Mykhailo said that this was done because of elections. And what was the reason in Latvia to adopt this administrative justice? And about the administrative process, how often does this law changes? I mean, in the sphere of public relations, you know, this is a normal development of democratic legal state. Each democratic state should have administrative processes and administrative courts. Of course, if we are speaking about the structure, these can be administrative judges in general courts, but we should have these administrative processes. This should be. And after in 1991, they started to say that we should introduce administrative process, and step by step it was done. And in 2001, there was a proper law, and we had 3 years to get prepared, and then the law was introduced into force. And this is a normal process, the instrument for the protection of people in relations with the state. And it exists in all democratic states. No, I mean about, do you consider many cases if compared with other jurisdictions? Oh, if you're speaking about the figures, I'm from the Supreme Court, so I can tell you about my figures. And I can tell you about the figures of my court. And now we have, you know, Ukraine is a big country. You have 46 million of residents, and we have less, about 2 million. So you should take it into account. In the Supreme Court in Cassation, we have about 1,500 cases in civil cases, about 1,200, and criminal case. This is cassation. This is third instance. About 200 or 250 cases. And the last question about the changes in the law in administrative justice. You know, we are trying to follow the situation, and we actively participate in elaboration of legal norms that can be introduced in administrative process. And we have such a, so each 4 or 5 years we introduce some changes. There can be minor changes, and we try to interpret this in order not to change the law at once. Our people from civil and criminal departments, they look at us and they see our results, not in 1 year or 1 month, but in 4 or 5 years we change something, because life changes. There are some different peculiarities, some changes, and they should be introduced into the law. I would like to ask Mykhailo Ivanovich about the efficiency of the Institute of Typical Exemplary Case, and whether this institute can deal with the problems in the system, and whether it should be spread to other jurisdictions, for example, economy justice. About the reasons of adoption of the code and the creation of the system of administrative justice, we brought it from the archives, the information about the hearings of the Verkhovna Rada and the deputies who want to continue to be deputies in the future. They motivated this, that there will be elections in the future, and courts should be created that will be able to consider such cases. And the basis for the creation of administrative courts and the adoption of administrative justice laws, the basis is if power does not afraid of its people, it should create the mechanisms to control the power. And this is the main reason for creation of administrative courts in Ukraine. And about novelties, about new things, we update the the things in the process. We get some interesting experiences from other countries. We know about how the cases in other countries and how they are considered. So these exemplary cases, this is not something new that was invented by us. Such procedures exist in Germany, in Latvia, of course. We have some peculiarities, and on the whole, this procedural institute of a typical case, it is aimed to make the justice more efficient. It provides dynamics to the case and its hearing, and it provides dynamic provision and proper restoration of violated rights. So this is not like a fight with the law. The main aim is that if there are typical cases, the exemplary case is heard, and the decision in this typical case is and this becomes an exemplary case for the lower courts, and when they have this direction of hearings, they can resolve these cases quickly, and these decisions they are implemented and they are not appealed against, and at the same time it helps to reduce the load. But the main thing is efficient, dynamic protection of human rights. And when we are speaking about proper rules, yes, we have some peculiarities, but on the whole, as of today, Cassation Administrative Court adopted 7 decisions in these typical cases, and they correspond their mission, and they do it in such a way, and people who didn't address the court, they got proper protection, because the entities, institutions, they made everything possible to reach proper practices, and those who addressed the court, they got proper decisions, and those who didn't address, they got proper they have proper relations with these institutions due to these decisions. And we had 39 complaints, and 7 exemplary cases were considered, and the last one was rejected because we do not see that this case is typical. And if we are speaking about private processes in the civil and the economy courts, speaking about those characteristics, those criteria about typical cases in administrative cases, I believe that we cannot use this procedural instrument there, because they have individual cases and no single entity from which the realization of rights of people depends. So unfortunately, there they have individual disputes, and we cannot use this instrument in those hearings. And the question to Mr. Lars about the number of years of the jurisdiction of administrative courts, and how often does your legislation in this area changes? About this history. More than 150 years administrative justice exists in Germany. At that time, Germany was not the state as it is now, but first was in Baden and in Prussia. And it historically influenced, and through the activity of these courts, we have proper administrative practice, and it was created under the influence of the decisions of these administrative courts. And this led to the formation of some dogmatic principles in relations between the state and citizens. And I would like to note that this is not a German trend. This was all European trend of creation of bodies of justice that would control the actions of administration. And such trends were in the territory of Ukraine because Ukraine is geographically in the center of Europe. And I would like to say that not only geographically, but politically, Ukraine is in all processes that were and that are ongoing in Europe. And for us, this is really important due to this collective activity, and Mr. Smokovych mentioned it, that due to the activity of administrative courts, we have some dogmas, some principles in legal relations between the state and the citizens. And these are the challenges, as my colleague from Latvia stated, when these laws are adopted in the countries that have little experience at the stage of their development. This is the challenge for the judges and for society and for the state. And if we are speaking about Ukrainian experience during these 13 years, administrative courts, they made the way in those forests, and now we may move ahead along the ways that were created. And in times of crisis, when social and political crisis is ongoing, administrative courts suffer the most because they have a particular task. And that's why administrative courts, they always say that they protect citizens and society, and also society and citizens should protect administrative courts. Let's take the voting rights or the right for peaceful assembly. The same about the protection of the free press in the country. Because if you want to rule the country based on democratic principles with the support of society, you should think about the protection of democracy and the proper democratic support of the press. That's why we should value the activity of administrative justice and the activity of our Ukrainian colleagues. And briefly about our cooperation. It doesn't mean that we meet only during the conferences. We work outside these events. We have sharing of experience at collegial level. Ukrainian colleagues, they visit us in Koblenz and they look at the activity of our judges. They discuss cases, so we have good, deep cooperation. And as you may see, we also visit, and we see that Ukrainian colleagues use new technologies, and we can learn from our Ukrainian colleagues. But this is possible only due to active sharing of experience, and also there should be a deep trust among the participants of this sharing. And about German experience, about the introduction of changes in administrative justice code, I believe that we have stable law. We rarely have changes. For example, now we have discussions about the need or the lack of the need to introduce changes to speed up the consideration of cases by administrative courts. And this is also connected with the fact that in Germany there is big load on administrative courts. Because of the crisis of refugees, a lot of people address to courts to get refuge, and these cases are considered by administrative justice courts. For example, in my federal land, 80% out of 100% of cases, this is about refuge and staying in the territory of this land in Germany. But it doesn't mean that our procedural code does not change. We have some changes and the grounds for the cases, and this is about the activity of the different institutions concerning the asylum seekers and other things. So administrative justice, it should get accustomed to the changes in the material cases, and about the changes. The last big changes were introduced in 1994. After this, we didn't have major changes in our legislation. Do you have other questions? If there are no, once again, I would like to thank the speakers and also our colleague Nadia for professional translation, and thank you very much.